Tyrone, always good to talk to you. Again, the million-dollar question here is that we still don't have a trial date, do we?
No, we don't, Jeremy. And, by the sound of things and what happened in court this morning, it does not look like we're going to have a trial date anytime soon. I mean, these systematic delays, the threats of applications that are going to be brought, there's just so many matters at the moment which are clogging up the system. So I'm afraid, in fact, if you ask me, I don't even think that we're going to have a trial date this year, notwithstanding what counsel for Jacob Zuma said. I mean, they would ideally like to have a trial date in October, but that's not possible if they're coming back in September.
So the state saying today that it was simply seeking a clarification of the date. It was emphatic, saying it would be ready in October to proceed to trial, telling the judge that if the trial were to start today, it could go ahead. It knew who the witnesses were, where they resided, even referring to international witnesses, again, because of COVID, not knowing when they could travel. Conversely, you have the defence saying that they find the shifting reasons by the state worrying, and this lovely phrase, seeking to egg dance through until 2021. So what I'm hearing is both sides saying they're ready, but they're not ready. Tyrone, are you still with us?
I'm with you, Jeremy.
So go ahead.
So, Jeremy, this is really unfortunate. There's just so much to be said on this score. So to start with, there are a few challenges. No doubt COVID is a huge challenge because what it does, it makes it difficult for the parties to have some predictability as to whether witnesses will be able to come to court. There are huge restrictions at the moment on movement of parties in court. So that's the one part. And given the fact that you also have people overseas in this matter who potentially would have to be subpoenaed to come to court, travel by those witnesses is a challenge. But those are not the only challenges. Remember, Jeremy, that a high court trial like this, before it can be set down for trial, before a trial date can be determined, the parties, the court has to certify that the matter is trial ready, so that the matter cannot then again be delayed when it's set down for trial. They're unable to do that, and that is causing a serious problem because every single time that they come to court, all these issues get raised and the matter cannot be certified as trial ready. I cannot see how this matter is going to be certified trial ready this year. That's a big problem.
Could you explain to us how that certification process works? In other words, what the court would look at in order to determine readiness for trial?
Right. So it must take a bit of time, but let me try and explain it this way, Jeremy. There are a lot of issues, there are a lot of things that have to be looked at before one gets to trial. So one example that came up today is that the indictment having been served on Jacob Zuma, telling him exactly what he's charged with, as well as Thales, and discovery then happens. What essentially that is that, well, we'll give you all the documents that we intend to rely on in court when we present the evidence so that you've got 4 sides of them and you can prepare accordingly. Jacob Zuma's lawyers have now seen this and said, well, you know what? We need some information relating to these charges before we can plead. So we're not going to be ready to plead in court before we've had those answered. You cannot certify a matter trial ready until there are responses to those questions. And it could be a number of things, where you say this was done, by whom was this done, things like that, which are essential to enable him to plead. Now, all of those issues, those preliminary issues, have to be dealt with. The court has to be satisfied that all the responses have been filed and all the parties can then say, right, we all have the information that we need to go to trial. All the documents that are necessary, we all have that and we are ready to proceed and there are not going to be any delays. Then the court will say, fine, the matter is certified as trial ready. We can then proceed to trial on a date. What is a date that suits all of you gentlemen and ladies? Then let's go on a particular date. That is certification in essence.
Now, the state is saying that the defence has been unfair because, and I quote, it's had since 2006 to ask for this clarifying information. Is the state correct, or is the state misinterpreting that?
Well, I think they're both playing to the gallery in this instance. See, while it is true what the state says, to say, well, they've known all of this for all these years, but the fact is that in the intervening period, up until now, there have been a number of applications and processes which, if Jacob Zuma had succeeded in, there would not have been a trial. So, one cannot put the cart before the horse and say, well, I'm going to start asking for trial particulars and so on, when there might not be a trial. You're instituting steps to prevent the trial from happening, as it were. I mean, you're saying this thing should actually be done away with. And so one's got to be careful to say how many streams can you run at one point. So if you're running all the streams of taking the matter to the Supreme Court of Appeal, taking it to the Constitutional Court, trying to have the charges thwarted, but at the same time you're expected to be filing. I mean, otherwise you would have insane amounts of paper going between the parties. So I don't think it would have been practical at the time to be filing applications for particulars. In any event, even if they had done that, the National Prosecuting Authority would have stayed them. So they would have put those aside pending the outcome of all those applications. So they really, in reality, would only have been dealt with after the failure or success of all these intervening applications.
All right, I've got one or two more things to work through with you. This one is quick, I'm sure. The withdrawal of the arrest warrant, was that surprising?
No, it's not surprising. That's pretty standard. Remember, Jeremy, that a warrant of arrest issued because an accused has not come to court, and especially in the circumstances where the representatives of the accused have put to the court and offered reasons as to why the accused is not in court. Whether the court accepts it or not, well, put that aside for a moment. The warrant of arrest was issued, but it was stayed. So on the next appearance, if the accused comes to court, if the accused then proffers good reasons as to why it didn't appear on the previous occasion, the court accepts those, then the warrants are then revoked by the court. That's a standard procedure. It happens on a daily basis in our courts.
Fair enough. Let's work on Thales now, the French arms company, wanting a review of proceedings. What, in effect, is it seeking?
As I understand it, their application, and I missed that part slightly, I sort of caught it in the middle, but as I understand it, their application, or the intended application, is one which is targeted at one or two or more of the charges relating to racketeering. And I stand corrected, but as I understand it, what they want is to argue that, look, there is no basis for these charges, and so they shouldn't really be there. But I stand corrected. But if that is the case, what it does is that it essentially brings us back again to all these intervening applications that we've seen in this matter, where they've gone to the High Court. And remember, this goes to a civil court, because it becomes a civil question as to whether the state is correct or Thales isn't correct. Now, the court has to adjudicate that. We know how long these intervening applications take. They go to the High Court, papers have to be filed. I'm not going to bore you with all the rigmarole of all the detail, the different affidavits. The difficulty and the challenge with that is that they have a date until September, a holding date of September. We're already in June. Is there going to be sufficient time for all that work to be done, the papers to be filed, for the High Court to hear the matter, a decision to then be rendered by the High Court before the parties reconvene in September to try and certify the matter? I don't know if 3 months is sufficient to do all of that. So that also throws a spanner in the works.
Just a final question from me, and I don't know whether I'm simply looking for a headline or not, but did you sense that the interaction among the legal representatives was a little scratchy, maybe a little tetchy?
Absolutely, Jeremy, and it's unfortunate. You can pick it up by... We have a way of addressing one another in court. Counsel refer to one another in each other as my learned friend. I certainly refer to state prosecutors as the state, as opposed to referring them by their second name. And the reason really is that you want to have some deference to the arguments that you are making, so that they're not personal. They're not directed at Mr. Dana, they're not directed at Mr. Skakano, Mr. Roo. They really are the case. We are merely representatives in the matter. The matter is not ours. The matter belongs to the state, and so one should refer to the state. The state is doing this, the state is doing that. But I find it, I'll be honest with you, a bit uncomfortable and distasteful that the parties keep referring to one another in their second name, because that creates an impression that this thing is personal. So I think that can be watered down. But second, and very quickly, what that has also done is that it evinces and shows that behind the scenes, these parties are actually having difficulty dealing with one another. And that is affecting the expediency of the trial, because if they're able to settle a lot of these issues that keep coming up in court and asking the court to then make rulings on, these are simple processes that they should, between themselves, be able to agree on. Questions of particulars or further particulars. There's no reason why there should be such difficulty in settling issues, and so the courts continuously have to come in to deal with these matters. That is really unfortunate.
All right, we're going to leave it there. Tyrone Maseko, thank you very much indeed for that analysis from Tyrone Maseko Attorneys.